Hello, and welcome to the Society of Construction Law Australia's podcast, the podcast where we look at technical and legal issues facing the Australian construction industry. My name's Melissa Yeo, and I'm one of the directors of the Society. On Melbourne Cup Day this year, the Society organised a breakfast event in Brisbane, kindly hosted by Corrs Chambers Westgarth. Our speaker, fresh off the plane from the SCL Hong Kong conference, was Adrian Hughes QC of 39 Essex Chambers in London. Adrian shared his lessons from success and failure in major construction projects before a large audience of industry professionals. For those of you who could not attend, this episode records Adrian's enlightening presentation. Be sure to subscribe to the Society of Construction Law Australia's podcast to be alerted when new episodes are available. We look forward to sharing further podcasts with you. I'm Melissa Yeo. Thanks for joining us.
Hello everyone, it's a huge pleasure to be here in Brisbane and a particular pleasure to be invited on Melbourne Cup Day to join the celebrations. And thank you all for turning out at breakfast, and I hope that it's a catalyst for everyone to get together and then have a wonderful day after this. So the agenda in brief is to look at some examples of problematic projects, then look at the London Olympics. In particular, because I'm a disputes lawyer, so I don't pretend to be an expert on the procurement and management of these projects, but looking at some of the features of the approach, but in particular the features of the form of contract used. And of particular interest is the approach to dispute resolution and dispute avoidance for the Olympic Games. And then track back to see just briefly if those experiences would have and approaches would have helped the failed projects. So, sample difficult projects. I'm going to look not in detail at all of these, but start with the new Berlin airport. I don't choose the Berlin airport out of sour grapes because of Brexit, but it's just an interesting overall project to look at. Scottish Parliament, and I don't choose that because of sour grapes. There was an independence referendum, and then I do get to Wembley, which is definitely a core UK project, English project. So start with Berlin. Germany has a hard-earned reputation for precision engineering and punctuality. But the long-delayed Brandenburg airport, according to the German press, is besmirching that good name and turning the capital into a laughingstock. Originally scheduled to open in October 2011, the airport has been beset by delays and is now running 5 billion euros over budget. And having anticipated opening in 2011, the ribbon-cutting ceremony is now scheduled for an as-yet unknown date in 2018, 7 years after the airport was supposed to open. So where's it all gone wrong? The problems first started to arise in 2012 when Angela Merkel and 10,000 guests were about to attend the opening, but it had to be cancelled due to a fault with fire alarms and smoke extractors. But that turned out just to be the tip of the iceberg. And a catalogue of major technical faults were revealed, including 90 kilometres of cables incorrectly installed, 4,000 doors incorrectly numbered, escalators too short, and the airport's roof being twice the authorised weight. That's not all. There have been allegations of corruption. The press claimed that the airport's planner-in-chief was not an engineer but an imposter. And there are worrying claims that a whistleblower at the airport was poisoned, although this has not been proved. All this is in the press. I'm just summarising the background. Heads have rolled. The former Berlin mayor, Klaus Weyrauch, who famously described his city as poor but sexy, was forced to resign from his post in part because of the airport fiasco. So getting down to an analysis of what went wrong, the key issues appear to have been, firstly, inadequate client skills with no outside expertise brought in. I mean, the public body client simply didn't have sufficient construction expertise to understand the importance of early planning, didn't bring in sufficient outside resources. A consequence of the lack of client skills was its failure to make a realistic assessment of the cost at the outset. And they rejected tenders from main contractors on the basis they were too high, and decided to appoint directly 35 contractors to construct the terminal on the basis that this would save costs. Another example of the lack of client skills was the client's inability to appreciate just how poor the planning and design of the project was, and that led to design and construction taking place in parallel. There was no adequate change management system in place. A key issue which caused delay and problems was the inadequate ongoing design of the fire services. As the building envelope increased in size over the design and construction period, the fire safety services were simply upsized rather than properly redesigned. The disputes multiplied, with a number of key advisors being fired, and once this happened, vital knowledge was lost. So perhaps the summary of the problems for that project: no client expert delivery team. Secondly, inadequate cost and program information preventing management of changes. Thirdly, inadequate provision for design changes. And fourthly, no tiered dispute resolution, which led to acrimony and division. So in summary, it's a project that looks like an almost perfect case study in how not to procure and manage a major infrastructure project. The next project, which I mentioned briefly, is the iconic Scottish Parliament building designed by Enrique Morales to be a spectacular Parliament building. It was commenced in 1999, planned completion with 2001, and it opened eventually in October 2004, a delay of 3 years. But the more spectacular increase was that the planned cost was £50 million, and the final cost was £431 million, with a cost overrun of 730%. And the barrister who was appointed as counsel for the inquiry described the position when he said, "In my respectful submission," of course, as a barrister, when you start with "in my respectful submission," you know something's coming to follow. The Scottish Parliament building project exemplifies a failure of procurement management of gigantic proportions and at almost every level of official and professional involvement. The primary cause of the problems appear to have been scope creep, namely changes to the size, scale and specification of the building while it was being built. But it was clear that the original cost estimate was woefully inadequate. The Auditor General made a number of criticisms, and there was a full inquiry report. The criticisms included reasons for the late delivery of the project, which were principally the production of design variations and the late supply of information, with some 10,000 change orders issued over the course of the project, with a design that was complex and novel. And, for example, the foyer roof had radical changes and increased in cost from 1.8 million to 7.3 million pounds. So there was a great deal of design developing during construction. And other reasons for increased cost. The original cost figures didn't give proper allowance for example, inflation, which increased by 19 million pounds, prolongation, 73 million pounds, or design development, 68 million pounds. So the Auditor General summarised the Scottish Parliament problems by advising, firstly, that the form of contracting should be chosen with care. Secondly, there should be performance incentives for contractors. Thirdly, that there should be a single point of leadership and control. Fourthly, that performance needed to be measured as the project unrolled. And fifthly, that there should be adequate time for planning and design before the project started. For 2 minutes, I just mentioned talking about scope creep and design prior to embarking on the project, a long-running series of cases with which I was involved which involved the most beautiful Herefordshire estate in the UK. The estate was it was a historic estate purchased by an individual who'd made a very large fortune in the mobile phone industry, and this was his pet project. And my client was an architect who'd done work for the royal family, and he was a wonderful architect, quite old-fashioned. He used to sketch his designs on a pad with beautiful artistic sketches. He didn't really bother too much about contracts, and he didn't really bother at all about controlling costs. And this client's brief to him was on one piece of paper, and he said, "Excite me." Well, of course, that is an invitation for not only a beautiful project, but a pretty expensive and possibly disastrous situation. So, anyway, the beauty and tranquility of the buildings and their surroundings belied the acrimony that surrounded the project at completion. And the client and his partner rather hysterically alleged that the finished project was a house of horrors. It looked beautiful when we looked around doing the site visit. However, it led to serial adjudications. It led to 6 or 7 court actions between a client and main contractor and ultimately client and architect. And the architect was alleged, amongst other things, to have failed to ensure that before practical completion was certified, a number of allegedly significant defects had been cured. These significant defects included an allegation that he had failed to ensure that a glass roof be incorporated in the moon pool to cover the outer perimeter to ensure that the maintenance staff were able to walk over it to reach the Italian fountain in the centre to maintain it. Needless to say, the night before the main action was due to start, it ended in a very substantial payment to the architect and confirmation that his good name was unaffected by this litigation. Wembley is an iconic stadium. It's a spectacular finished product, but Wembley was a project which ended up in court in extremely expensive serial litigation and adjudication. There was a 1-year delay in the project, and there was a cost overrun from £757 million to £1 billion, of 32% cost overrun. But the most spectacular aspect of this was the acrimony and the costs that were involved in the resolving some of the disputes. Just a snapshot of the dispute between the main contractor and the steel work subcontractor. It was a £60 million subcontract to design, fabricate and erect the structural steelwork under a JCT subcontract. It was unusual because of the novel load-bearing steel arch, which had been hard to estimate in terms of cost and duration. But a look at the chronology of the subcontract reveals how it spiraled downhill. So it started with the subcontractor alleging that the design was incomplete and it was being held up, so claiming extensions of time, sending letters of protest. The main contractor alleged poor performance and delay by the subcontractor. And so at the end of the first year, the parties were both blaming each other and making extravagant claims for extensions of time and counterclaims and contra-charging from certificates. Hostilities resumed after Christmas, and there were board meetings held by the main contractor and separately by the subcontractor in February the following year. And at the same time, the subcontractor was developing a plan to allege that the main contractor had repudiated the contract and that the contract was at large, and they called this plan Project Trafalgar. At the same time, the main contractor was hatching its plan to resolve the difficulties and that it should replace the subcontractor with another steelworks subcontractor and pursue substantial financial claims. It called its plan Armageddon. it was Plan Armageddon that hit first. And after the arch had been raised, despite some problems with alleged defects in the steelwork, the main contractor, through the subcontractor off-site, there were then 5 adjudications. The adjudicator came out with a balance of account. Neither party was happy with that. And they commenced proceedings. The first action involved 11 preliminary issues. And the costs were tens of millions of pounds, including £1 million for photocopying alone. Mr. Justice Jackson, who's one of our principal construction judges, said in a further case in 2008, the preliminary issues case was 2006, I previously expressed concern that this litigation has been conducted in a disproportionate manner. Most litigants in the TCC, the Technology and Construction Court, adopt a commercial approach to dispute resolution once they've obtained the court's decision on liability, and on questions of principle, litigants usually agree upon valuation and similar matters to limit costs. In the present case, that's not the approach of the parties, despite having litigated both at this level and in the Court of Appeal on a number of issues. Instead, vast and disproportionate costs have been incurred and continue to be incurred in litigating about matters which cry out for sensible resolution and compromise. And a summary of the problems might be that the form of contracting should be chosen with care. There's a need for trust and cooperation between the parties, not immediately descending into acrimony. The need for performance incentives for contractors. There was no client leadership and control in that situation. There should be adequate time for design and planning before the project starts. There was a need for transparent provision of programme delays and the regular assessment of extension of time. There was a need for dispute avoidance to prevent Project Trafalgar or Project Armageddon, and the adjudication was all too late and in any event not accepted, and just enhanced the acrimony. And finally, there was a need to prevent spiralling litigation costs and enable some sort of alternative dispute resolution. I'm going to move on to the positive approach in a moment, but so I don't really have time to go into the circumstances of the other cases that I mentioned, which are problem projects. But Gibraltar and Obrascon has been a prominent case for a number of issues in our courts, first instance and Court of Appeal. This was a development of Gibraltar Airport which involved tunnelling. The contractor found more contaminated material, particularly arising from the use of the airport area location as a military site. And there was a dispute between the employer and the contractor as to who should bear the risk of the volume of contaminated material. But one of the problems was that it only gradually, the scale of the problem only gradually developed so that it involved very substantial delay to the project, which increased the difficulty of resolving those issues. Although the resolution of the liability issue was a matter of contractual interpretation and a matter of the risk allocation as a matter of law, which might affect any project. But it wasn't picked up early enough, it wasn't addressed early enough, there wasn't a cooperative approach to the project. The fifth example of a project that I had originally in the list is an offshore wind farm, the Solway Firth, which was the most recent case to reach our Supreme Court, and called Hoggard, and it involved a dispute over the design responsibility for the failure of the concrete columns. Different decisions were arrived at, first instance, then Court of Appeal, and then the Supreme Court as to who was responsible. In the end, it was held the contractor was responsible. But I'll mention that in the context of the NEC contract at the end. The final example was the Shard, which is an extraordinary building in London, the tallest building in Europe, and its construction involved steelwork up to 43 floors, I think, and the first 9 were delayed, and the impact of that delay and the impact on the programme was the issue in the case. But part of the problem was the lack of programmes that could assist both in resolving the problem and in then resolving the court case. And the experts, delay experts, had difficulty in being able to explain and persuade the court as to the liability and the impact of the delays. So I'm going to, before I go to the Olympic project. It's easy to overlook that after the award of the Games in 2005, the Olympic Delivery Authority was created to deliver the infrastructure for the Games, but it was a difficult situation at the outset because the ODA had inherited a site that suffered from generational neglect. It was tasked with delivering a construction programme twice the size of Heathrow Terminal 5 in half the time. The contractors in the public sector at the time were cynical about the project. The economy was buoyant, which reduced the appetite in the supply chain. But if one then moves forward, by 2012, the ODA had delivered on time and within budget these major projects, including the Olympic Stadium, the Velodrome, the International Broadcast Centre, the Aquatic Centre, the Athletes Village, and the temporary structures. And one sees the statistics for the complexity of the project, and they had used for the majority of these major projects the NEC contract form, NEC 3. And in a moment, I'm just going to summarise some of the approaches of the NEC contracts. But before getting there, it's worth just looking at some aspects of the approach to the management of the project, because it was largely the project management that contributed to the success of the project, although one has to bear in mind that this is a project with major political clout, major funding. It couldn't go wrong. So then one needs to see whether the approach and the contract would apply with equally problem-free to other infrastructure projects with less public prominence. The ODA established a learning legacy from this project with a collection of published reports that are accessible on the internet to look at the detail. And that resource has been followed with Crossrail as well. Looking at some of the themes in the approach, firstly, the use of a delivery partner. The ODA recognised that even with high-quality individuals it had in-house, it still didn't have sufficient construction and project experience. So it hired a delivery partner, and the delivery partner approach is attributed by the learning legacy analysis as being a fundamental aspect of the success of the project. And the delivery partner was engaged under the NEC 3 professional services contract. Secondly, during the detailed design and construction, high-quality project management techniques were deployed with very detailed information on cost and programme required from the Tier 1 subcontractors. Thirdly, the use of the contract, I'm going to come on to in a moment, sat alongside a raft of management tools, including a suite of monthly reviews, which focused on different aspects of delivery. And they involved monthly cost reports and monthly project status reports produced by the delivery partner, looking at information from the Tier 1 contractors. And finally, a change control procedure was put in place and a control culture fostered with trust in the accuracy of reporting, and the baseline was updated to a current baseline budget. The NEC 3 contract was used for the majority of the projects. It's a contract which has been used and is being used internationally as well as on these projects within the UK. It's used in South Africa. It's now used widely by the government in Hong Kong. And it was even found in the project for the building of Halley Base in Antarctica. I understood when I came here that it had only been used on the Mount Mercer wind farm in Australia. But as I've visited the different cities where I've talked, it's clear that the NEC 3 contract, and not just the principles behind it, is being used in, for example, highways projects in Perth. So just looking at the way in which some of the principal features of this contract. Firstly, it takes an approach that encourages a collaborative relationship between the parties. There's a clause which provides that the parties should act in a spirit of mutual trust and cooperation. It has been argued that that incorporates a duty of good faith, but the courts in the UK have rejected that. But quite whether that makes a difference is unclear. But the ethos can be a very powerful driver. It creates a different relationship and atmosphere for the project from the outset. Secondly, these contracts provide a clear methodology for project management with processes and procedures clearly defined. This was particularly important in terms of the obligations to provide detailed cost and programme information on a regular basis. Thirdly, for many of the Olympic projects, there are different options that can be chosen by the parties, which include two, which include a target contract, including a pain and gain share approach. And this offers an incentive in the form of a share of the gain to the contractor to complete the works for less than the target price, and a disincentive in the form of a share of the pain if the works are completed for more. The target cost is set from a priced activity schedule, which is then adjusted as the project proceeds to take account of compensation events. The contractor's paid its costs as the project progresses, but then a balance is struck on completion or as agreed. The fourth important aspect is that the contract provides for an accepted programme, which is regularly updated. And the accepted programme is, it starts its life in the contract data, and it is then adjusted and amended at an interval that's agreed between the parties, not more than 4 weeks. And the contractor must show a detailed range of data in the programme, including actual progress and its effect on the timing of the remaining works, the effects of compensation events, how the contractor plans to deal with delay, and any other changes the contractor proposes to make to the programme. And then the project manager, on behalf of the employer, either accepts the programme or rejects it, and there are specific reasons for rejection which are set out in the contract. And the fifth feature is that of early warning notices, which the contract requires the contractor and the project manager to give early warning by notifying the other as soon as either becomes aware of any matter which could cause an increase in costs or a delay. The early warning notices in the Olympic projects appear to have been successful. There were 21,000 early warning notices for the Olympic projects. This was a changing culture because contractors, normally unused to providing notice of problems which may indicate shortcomings on their side, but the ethos of the approach to the parties and the requirement for these notices in the Olympic projects ensured that potential problems were addressed at an early stage. As soon as they became apparent, they're discussed. They're added to a risk register. There's a risk reduction meeting, and they have a direct relevance to payment. Compliance with the procedure has a direct relevance to payment under the contract. The sixth feature is that of compensation events. And these are events which change the cost of the work or the time needed to complete it, and for which compensation may be given, may be an entitlement. And examples, the project manager giving instructions to change the works information, the employer not providing something by the date required, or a breach by the employer, or unexpected physical conditions, etc. But what marks out the NEC 3 contracts is the manner in which these events are dealt with. They have to be notified within an 8-week period. There's a time bar. They then first have to be discussed between the contractor and the project manager, and at the discretion of the project manager, they're addressed by quotations by the contractor, and the project manager may make his own assessment. And once that is agreed, then those quotations and the agreed assessment, they're based on a forecast, and they bind the parties unless it's later shown that the information used as the basis has been wrong. So that's a review of some of the main features of the contract used for the Olympic projects. The dispute resolution approach is of particular interest to was to me and will be to dispute lawyers, because the NEC 3 contract incorporates a provision for adjudication, and then because we have statutory adjudication, essentially a 28-day process with a temporally binding decision. If the parties don't like it, then they can then proceed to take their claim to the tribunal. The tribunal is either the court or arbitration, and in the case of the Olympic projects, it was the courts. The courts had re-established themselves as as what's perceived to be the most reliable form of tribunal for ultimate resolution of the disputes. But importantly for the Olympics, the provisions of the NEC 3 contract were amended to include an escalation clause for reference to senior executives for negotiation, and then this very interesting independent dispute avoidance panel. And the avoidance panel was an 11-person panel. It had two functions: one, a general function for avoiding disputes generally and running training and education for the parties and project managers. But then if a particular issue arose, it was referred to the panel. A designated member was appointed to try to assist the parties to resolve their issue before it became a dispute. And that's an informal process, and it proved to be very successful, because only 2 of the potential disputes got through the dispute avoidance panel and reached the adjudication panel, with one of those 2 adjudications being suspended. And it appears that only one case reached the TCC for resolution in court, and that was the dispute involving the construction of the Athletes' Village, and it was a dispute between the main contractor and concrete frame subcontractor. The subcontractor made a claim of 7 million, the main contractor counterclaimed for 7 million, and the case disappeared. But it was successful dispute avoidance and dispute resolution. And the new form of contract, NEC 4, which was released in June this year, makes a number of incremental improvements and changes. But one aspect of that is to incorporate the Olympic approach in NEC 4 to include escalation through management and dispute avoidance and dispute adjudication boards. I'm just looking at how this approach might have resolved some of the problems that were experienced in these projects. Well, with the Berlin airport, the problems were no client expert delivery team, inadequate cost and program information preventing the management of changes, inadequate provision for design changes, and no tiered dispute resolution, which led to acrimony and division. Well, you'll see that some of the approaches from the NEC 3 contract and the management approaches to the Olympics could well have assisted with avoiding the problems that were experienced with Berlin, although one may well have had a number of those problems in any event. But it assists by addressing problems, flagging them up early, everyone knowing about them early, resolving them as early as possible, and then having a tiered dispute resolution approach. The Scottish Parliament perceived to, in particular, that there should be performance incentives for contractors, that there should be a single point of leadership and control, that performance should be measured as the project unrolled, and that there should be adequate time for planning before the project started. Yes, if they'd taken an alternative approach along the lines of the Olympic approach, then that could well have resolved a number of the problems that they faced. And Wembley, similarly, the need for performance incentives for contractors, adequate time for planning before the project started, the need for transparent provision of programme delays and a regular assessment of extensions of time, and the need for dispute avoidance to avoid a situation such as Project Trafalgar or Project Armageddon, and try to avoid the adjudications and serial expensive litigation. The Olympic approach could well have helped in relation to resolving some of those problems as early as possible. The NEC contracts are not trouble-free, and I think from my personal perspective, if one's using NEC 3 for example, local authority, highways, term contracts, then there are potential problems because they're very resource intensive. They need a lot of education of those operating the contracts. With the Olympics, there was a huge program of education of both the employer team and the contractors and subcontractors. And a local authority employer may well find itself requiring resourcing to educate its personnel, and also the resources needed to deal with the early warning approach and the addressing compensation events early. And in cases that I have come across, experienced contractors can hide some of the pricing information and some of the detail in the detail that's required in the contract data and the works information, which can be quite confusing. So that perhaps a word of warning for the lower scale projects for using these contracts. Some of these cases pick out particular issues, and the first one, TSG in Anglia, that was a case where it was alleged that a local authority couldn't terminate because it owed, there was a duty of good faith, and it was terminating a term contract just after the contractor had invested hugely, and it was clearly unfair, but it was entitled to do so under the contract, so that was not a good enough defence. AMEC and the Secretary of State of Defence, that was a court being asked to interpret the very complicated pain gain share provisions in a submarine maintenance contract, so that there was a clear provision that for the first 50 million above the target contract, the target price, the contractor should bear that. But then there was ambiguity as to what happened if there was an even greater loss. And the court had to resolve that ambiguity. RWE and Bentley is a conflict between provisions for what tasks were required prior to sectional completion in two different parts of the contract data. And the Atkins and Northern Ireland are cases involving interpretation of compensation events. With Atkins, it was a highways maintenance contract, and the contractor had alleged that it had found a greater volume of or frequency of potholes, which had been extremely expensive. And the adjudicator in the court held that it couldn't complain. They weren't defects. The volume of or the frequency of the potholes didn't constitute defects under the contract, which would have entitled a compensation event, but that they were they had taken the risk because it was not a pain gain share option. It was a priced contract, and that if they'd been entitled to recover because they had found more than they'd expected, then they would have had a win-win commercial situation where they would have been entitled, if they'd found less, to the lump sum, so they were not entitled to compensation events. But they're just a sample of the increasing jurisprudence arising from NEC3 as one sees these contracts applied and different types of project, different levels of project, so that the picture that one sees from the Olympic projects is not necessarily as rosy in relation to other forms of contract, other forms of project, but the approach broadly helps if it's sufficiently resourced. I want to mention briefly the Crossrail project, because that is an extraordinary project. It has just over a year to go until the new Elizabeth Line railway opens in December 2018. And the programme's running on time and on schedule to be delivered within its £14.8 billion budget. The route will run 100 kilometres from Reading and Heathrow in the west to Abbey Wood in the east. There'll be 40 stations, including 10 new stations. And the first services will start in late 2018 and are estimated to carry 200 million passengers per year. It's the first complete new underground line station in London for more than 30 years. Tunnelling began in summer 2012. 8 1,000-ton tunnelling machines have bored 26 miles of tunnels under London. All the track has now been installed, and the project's entered a new phase. Its construction trains are now able to travel the full length of both new tunnels from end to end. Since construction of the new railway began, over 15,000 men and women have worked on the project, and over 100 million working hours have been completed. The client took certain approaches as commercial drivers for the project. Firstly, in relation to a pain gain share, there was it adopted a simple 50-50 pain gain share as a fair and balanced approach between employer and contractor. Secondly, in relation to completion dates, with so many interfaces between the contracts, it was essential that contractors achieved interface milestones on time, and the client extensively used key dates and section completion dates with appropriate damages across all the contracts. The NEC3 Option C target contract was used for the 36 main works contracts with a total value of approximately £6.5 billion. A number of amendments were made to the standard NEC3 contracts, which included the use of a geotechnical baseline report as the basis for assessment of compensation events for physical conditions, a payment cycle that would accord with our statutory payment regime within a 30-day, entitling payment within a 30-day period. The client was permitted to deduct the pain share, if there was a pain share, before completion to avoid the need to take action after completion. Performance bonds of 10% were used rather than retention or retention bonds. Parent company guarantees were taken. The contractor was required to take all reasonable steps in mitigation of any compensation event. It couldn't just sit back and claim that the entitlement. Project bank accounts were used, and contractors were required to pay subcontractors directly from the account. And the NEC in that case required a great deal of formal communication. Over 150,000 separate communications were issued under the works contracts, and the client chose the most up-to-date communication system and document management system, allowing the integration of communications with documents, reports and drawings. So as for dispute resolution, it considered the approach taken on the Olympics, and rather than adopt a dispute avoidance panel, it chose a panel of adjudicators as the most appropriate option. But it did include a provision requiring managerial discussions. The client apparently encountered a number of disputes with contractors, mostly revolving around issues of time, but generally engaged successfully in managerial discussions to reach agreement. To date, it's recorded that the client has had just one formal adjudication in relation to the main works contracts. And as of the middle of this year, 19 of the 36 main contracts have reached formal contract completion, all of which are commercially settled. And none of these completed contracts have any outstanding disputes. So I just wanted to mention my understanding of the work of the SCL in revising the ASC 11,000 standard form Australian contract. And the SCL Australia has been asked to participate in the drafting of this revised contract. And my understanding is that they have included the following aspects of the approach that we've been looking at in the current drafting. Firstly, there is an express obligation to exercise good faith, so that it goes further than the NEC requirement for mutual trust and cooperation. Secondly, an early warning process has been included, requiring the superintendent, the employer and the contractor to give notice of a problem, and that links into the dispute avoidance process. Thirdly, for as far as the equivalent of compensation events is concerned, there are no time bars, and the failure to give a timely notice sounds only in damages but doesn't preclude remedy the recovery of the claim. Fourthly, in relation to dispute resolution or dispute avoidance, a facilitator is appointed who can assist by with a number of steps, service provisions. He or she will consult as necessary, will chair the early warning process, will chair the updating of programs, make recommendations, give an advisory opinion, and can make a non-binding determination. But if the parties can't settle, then there's a choice between arbitration and expert determination rather than the use of the court, which is the approach that we're more likely to take now in the UK projects. And there is no incorporation of dispute adjudication boards, which are considered to be too complex. So the aim is to adopt a modern approach and avoid a combative contract approach in these contracts. So it'd be very interesting to hear more about the progress of that. And very interesting to hear from you about your experiences. I know that just from my short conversations before we started that that a number of different approaches have been taken to project management, education, and the contractual approach in projects with which you're involved. Wrapping up, what lessons might be learnt from some of the failed projects, some of the more successful projects? Firstly, they come under the head of project management, getting the right people in the right roles at the outset, getting realistic estimates of cost and time at an early stage, ensuring that the design is properly developed and the client's requirements are identified before contracts are placed, putting in place systems that provide accurate information as to cost and time, making that information available to the client, so transparency being crucial, ensuring the client has sufficient skills to understand that information and act on it, and ensuring that problems in terms of quality, cost and program are identified at an early stage, and that the processes, the information and the skills are available to resolve those problems when they arise. And secondly, the contractual framework and the legal strategy ensuring that the contract supports those management aims, and they might include gain sharing incentives which align client and contractor interests, the obligations to provide early notice of problems, obligations to provide specific types of information on a regular basis, and then a tiered dispute resolution process. But not all management approaches and contractual approaches can solve all problems of the contract, and this was the most recent experience of Halley Bay Antarctic Station, and a massive crack appeared too close to the station soon after construction, and last winter it was decided that the station should be moved to safety, and a major project was conducted to move it. But it was interesting that the NEC contract was used for the construction of this station, because there's only a 9-week window for construction and dramatic weather constraints, and a need for a very, very different approach to contracting to achieve a successful outcome. So Halley Bay is now at its new home, and because of my interest in Antarctica, I was looking more at the Australian experience, and your hero is Sir Douglas Mawson, and I'm not sure whether this talk is tied in with Adelaide, because Douglas Mawson, he was born in Yorkshire, but he lived there to the age of 2. He then came to Australia. He is a geologist, and he took part in Shackleton's early expedition, and he was then invited by Scott to join his ill-fated expedition, but he decided that he would run his own expedition to a part of Antarctica that subsequently became the Australian sector, and he had an extraordinary adventure during the course of that expedition, and he then returned to Australia he became a professor at Adelaide University, professor of geology. He only died in 1958. But the main Antarctic explorers all revere Mawson as being the true explorer and an expert geologist. And there are regular or periodic expeditions to ensure that his heritage and his huts are properly maintained in Antarctica. And so I have a particular interest in that aspect. That's all I wanted to say. Thank you very much I appreciate that you come so early in the morning for breakfast. It's terrific to be invited to join you, and I hope that you have a wonderful Melbourne Cup day. It's great to have the chance to be here and to meet with you. Thank you very much.